All right, let's dive right into this explainer of a truly landmark constitutional court case out of South Africa. We're looking at a fascinating legal battle where deeply held religious beliefs collided head-on with the state's absolute mandate to protect children. The case is Christian Education South Africa versus the Minister of Education, and the judgment was delivered by Justice Sachs. It is literally a textbook example of how a modern democracy wrestles with competing fundamental rights. To see how the court untangled this, we'll walk through 6 parts: the blanket ban, the religious freedom claim, protecting the child, the balancing test, the final verdict, and finally, the missing voice. So what's the big question here? Well, it boils down to this. Does a nationwide ban on corporal punishment in independent schools violate the constitutional rights of parents who, based on their faith, actually consent to its use? It's an incredibly tough question that forces a society to weigh absolute faith against absolute law.
Starting off with Section 1, the blanket ban, the 1996 Schools Act.
Look at how fast this journey played out. It all starts in 1996 when the South African Schools Act was passed. Almost immediately, there was serious pushback from independent Christian schools who felt this new law stepped right on their religious practices. They challenged it in the High Court in 1999, but their claim got dismissed. That led them to appeal directly to the highest court in the land, the Constitutional Court, in the year 2000.
The spark for all this conflict? It was this uncompromising blanket prohibition in Section 10 of that act. No person may administer corporal punishment at a school to a learner. The language is totally definitive. You see, the post-apartheid government was actively trying to usher in a new nonviolent era of education. They wanted a radical break from an authoritarian past where state-sanctioned physical force was just the norm. But for a specific group of parents, this ban was seen as a direct attack on their faith.
Moving right into Section 2, the religious freedom claim, faith and discipline. 196. That represents the number of independent Christian schools that brought the appeal, covering roughly 14,500 pupils. They argued that corporal correction, which is the specific term they used, was an integral part of their active religious ethos. They weren't just asking for the right to hit kids. They were arguing that physical discipline was an absolute biblical requirement for raising a child properly. To them, preventing it meant they simply couldn't practice their religion freely.
This really illustrates the direct biblical foundation they relied on. The parents cited Proverbs and Deuteronomy to argue they have a divinely imposed duty to physically discipline their children. They believe their faith absolutely requires them to use the rod, and when they send their kids to an independent Christian school, they are officially delegating that God-given parental authority over to the teachers.
And they made sure to point out to the court that this wasn't just random violence. They argued it was a highly structured, emotionally supportive procedure delegated through formal signed consent forms. It was an actual multi-step process. You investigate, match the offense to a biblical principle, position the child safely, apply a maximum of 5 strokes with a cane or a ruler, and you conclude the whole thing with a hug and a prayer. In their eyes, this was discipline, for sure, but absolutely not abuse.
Which brings us to Section 3, protecting the child, the state's mandate. While the government certainly didn't just back down, the state countered those religious claims with a massive constitutional arsenal of its own. They invoked Section 9 for equality, Section 10 for human dignity, Section 12, which guarantees freedom from violence from both public and private sources, and Section 28, which specifically protects children from degradation. The state asserted its overarching duty to protect learners from what it viewed as institutionalized physical assault.
The crucial point for the government is that they view the cane not as divine correction, but as a severe violation of human dignity. They pointed out that South Africa had suffered a massive surfeit of violence historically, and physical punishment in institutions echoed that dark, authoritarian past. Backed by international treaties like the UN Convention on the Rights of the Child, the state argued they had a constitutional obligation to build a new culture, one where problems in schools are solved through reason, not physical force. Okay, on to Section 4, the balancing test, colliding rights.
We have 2 incredibly compelling, perfectly sincere arguments here. On one side, freedom of religion. On the other, the physical protection and dignity of children. So how on earth does a court resolve a deadlock like this? Picture a giant scale. On one side, the Constitution promises that religious communities can practice their religion together, but on the other side, it also promises that everyone has the right to be free from violence.
To break that tie, Justice Sachs used Section 36, known as the Limitations Clause. This is a specific legal mechanism in the South African Constitution,
which recognizes that almost no constitutional right is 100% absolute. Rights can be limited, sure, but only if the court decides that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. Now, the parents actually tried to argue that the court should use the American strict scrutiny test. That test requires the state to prove a compelling state interest any time they burden a religious practice. But the court explicitly rejected that rigid American model. Instead, Justice Sachs favored the South African Section 36 test. It's a global judgment on proportionality that is highly nuanced, looks at the specific societal context, and directly weighs the importance of the right against the core purpose of the limitation.
Let's look at Section 5, the final verdict. Justice Sachs's decision.
Applying that nuanced proportionality test brings us to the actual resolution. Justice Sachs drew a really brilliant distinction here. He looked closely at the environment where the punishment was happening. While parents might discipline their children at home in a spontaneous, private, familial setting, the school operates completely in the public domain. It's an institutional, detached environment. Because the school prepares learners for broader society, state norms regarding health, safety, and violence simply have to prevail there. The state isn't entering the private home, but it absolutely regulates the public institution.
So the court ultimately ruled against the parents and upheld the ban. Why? Because the blanket ban serves a massive symbolic and pedagogical purpose. South Africa was trying to fundamentally transform its civil society and completely eliminate state-sanctioned physical force. Allowing an exemption for these 1906 schools, even if they sincerely requested it, would totally undermine the state's monumental effort to build a uniform, nonviolent educational system.
The court decided this limitation on religious freedom was completely justifiable. And the big takeaway you should remember here is that believers aren't being forced to completely abandon their faith. The state isn't saying they can't be Christians, parents can still raise their children in their Christian ethos, they just have to adapt their school's disciplinary codes to align with the country's secular laws against violence. Basically, they just cannot authorize teachers to cane students on school grounds.
And finally, Section 6, the missing voice. Who speaks for the child?
That was the final legal verdict, right? But wait, there's a really fascinating postscript here at the very end of his judgment that shifts the entire perspective of this case. The court noted that throughout this whole lengthy legal battle, a curator ad litem was never appointed. That's an independent legal representative for the children. Think about it, both the parents and the state stood up in court and claimed to know what was best for the child. The state argued the children were victims of degrading violence, while the parents argued the children were receiving loving, biblical discipline. Yet no one was legally appointed to speak strictly in the name of the teenagers themselves, to share what their actual lived experiences were.
Justice Sachs pointed out that hearing directly from these older students would have deeply enriched the dialogue and given the court a much more secure factual foundation. It leaves us with this incredible, provocative thought to take away. In these high-stakes constitutional battles over who gets to dictate a child's upbringing, the devout parents or the protective state, shouldn't the child's own voice actually be the loudest one in the room? Thanks for joining me for this explainer.